Aloha, this is Professor Porter. We're talking about the Federal Rules of Evidence and specifically Rule 403, what has to do with unfair prejudice or other dangers referenced in the rule. And really, even before we introduce the rule in its simple text, this is a very popular rule. Think about it as the last-ditch effort, the last hurdle that you would have in a series of objections. You're imploring the court as the opponent, the one objecting. You're imploring the court to exercise its discretion here under this rule and keep out potentially dangerous evidence, unfairly prejudicial evidence, cumulative evidence, misleading to the jury evidence, evidence that is really just designed to delay. There are dangers that are mentioned in this rule, and really what you're saying is, against this balancing test, judge, use your discretion and keep this out under Rule 403 at the back end of all my other evidentiary arguments that come before it. Here's the rule in the simple language of the rule. Notice that it starts off by saying, although relevant. We're assuming that it clears the foundational step of relevance under 401, that it gets over that speed bump of a rule, and that otherwise it does have some tendency to make a fact of consequence more or less probable than it would be without the evidence under the test of 401. This instead says, well, let's engage in some balancing. Let's think about a balanced test. And what are the two things we're balancing? Sometimes it's tough for folks new to evidence to understand this. We're balancing essentially the value of this evidence, the weight of this evidence. So if you think of Rule 401 when we discuss relevance, it was like an on-off switch. Relevance only has a test. It either meets it, it's relevant and therefore admissible, or it's irrelevant and therefore inadmissible. There's no degrees of relevance. Things are not super relevant or really relevant or totally relevant. Things are relevant or irrelevant. And even if it's weak evidence and pass that test, I always give the example of maybe there's a red car driving away from a bank robbery. And then when we picked up the government picked up a suspect, they noticed there was a red car in the driveway. Well, the government intends at trial to put on that evidence as it goes to identity. And one of the things the criminal defendant wants to say, and the attorney on behalf of the criminal defendant wants to say is, yeah, maybe it has some tendency to make it more likely that this is the person that did it, but it's so weak. I mean, how many red cars do we have in the world? It's so not specific. And this is the place where we weigh evidence. And instead of using the word relevance, instead of using that label to weigh, because relevance is just that on-off switch of relevant or irrelevant, we give it a value called probative value. So how weighty, how important is the evidence? My red car example, it has low probative value. Sure, it goes to identity, it's admissible, but it doesn't move the ball all that much. It would need to be combined with lots and lots of other evidence to actually establish identity at trial. Whereas you think of some other evidence that could be for identity. Imagine if you had a video of the person committing the bank robbery, and among the other things that it's admissible for, it's admissible for identity because it shows the person doing it. That's very strong or weighty or significant probative value. So that's one of the scales, the probative value. How much on behalf of the proponent does this evidence move the ball? How good is this evidence? How significant is this evidence given the theory and the presentation and the elements of the claim or crime? And then the other side of the scale, the other side of the balancing test, are these dangers. They're not all created equally. Unfair prejudice is the biggest one. It is the one that would, if they were all Instagram personalities, it's the one that would have the most followers by far. The rest of them only show up in a relatively small percentage of cases. Unfair prejudice is the big one. And really think about those terms, unfair and prejudice, as being married. All evidence that one side puts in, the proponent puts in, that's good for them is necessarily damaging or not so good for the other side. So therefore, all evidence that moves the ball for one side is prejudicial to the other. This rule, the danger focuses on unfair prejudice and then lists those other dangers. So that's the other side of the scale. Probative value on one side, unfair prejudice and the other dangers on the other. For me, especially if you're looking at it in an evidence discussion or an evidence exam, if you have different arguments to make, like evidence is unfairly prejudicial and there's a confusion of the issues and it misleads the jury, treat them as separate objections and weigh them separately and make separate arguments to the court in a motion in limine. So we have our two sides of the scales. We have the probative value, how is the ball advanced? How did we move the ball in this case for the proponent? And we have the dangers that essentially the opponent warns us of. Those are the two sides of the scale. And essentially to have a successful 403 objection by the opponent, when they throw that flag on the field, when they sound this alarm, objection 403, objection unfairly prejudicial, the scales have to be oriented in a certain way to be successful. And that is one of those dangers, the unfair prejudice, has to be significant, has to be weighted down. And the probative value has to be relatively insignificant or low. So the scales are really cranked to one way, such that we can argue that these two words have to be married together too, such that the opponent can argue the unfair prejudice, or one of the other dangers in a separate argument, the unfair prejudice is substantially outweighs the low probative value. The scales are cranked in this way. And because they're cranked in this way, Your Honor, I can make an argument to you that unfair prejudice substantially outweighs the probative value. And this is the case, and this is the evidence where you should exercise your discretion under this rule, because it is a may. You should exercise your discretion under this rule to exclude this evidence. So I always like to start with what side are you on? If I am the opponent, I'm going to start with the unfair part. I'm objecting because I think it's unfair. I'm objecting because it's one of these dangers. So I start my evidentiary argument once I'm over at sidebar. Once I say objection, unfair prejudice, objection under 403, I get over to sidebar. The court turns to me as the opponent. I'm the one that objected. I'm the one that threw the flag on the field. And I say, Your Honor, this is unfairly prejudicial because I talk about this one side of the scale first that I think is the reason why they should exercise their discretion. So I talk about that first. Next, I would go to essentially that probative value, and I'd be talking about why that probative value relatively is really light. Maybe it's like my red car example. It just, sure, it goes to identity, it's admissible, but it's a very low weight, and we expect the jury to assign very little weight to it. So I talk about the relatively low probative value of the evidence and the relatively significant weight of the unfair prejudice, the danger. And I use because in both of my sentences. This has very low probative value because in my second sentence. This has significant unfair prejudice in my first sentence because. And then once I get those two sentences established where I've oriented the scales in this way, where the scales are sufficiently cranked as the opponent, I go to this balancing test. So therefore, the unfair prejudice that I described substantially outweighs the probative value. And you can think about the sentence could be phrased the other way with a different tense of the verb. The relatively low probative value that I described is substantially outweighed by the unfair prejudice that I described. My third sentence just describes how the scales have to look. It describes how I have to meet the test. And then my final sentence is, therefore, Your Honor, this is the case where you should exercise your discretion under 403 and exclude this evidence. This is the case where you do your thing under 403. And I want you to think, what is that? What's the other stuff that goes in this argument? Just imagine all evidence we don't, these are quotes taken from cases. We're not looking to have evidence inflame the passions of the jury. That's a quote that comes from a case. Evidence should be admitted, should not be admitted only to provoke emotional reaction from the jury. We want juries to neutrally decide the case on the facts. Facts might be gruesome, facts might be damaging to one side or the other, but it's not supposed to do this tugging on the heartstring, provoking the emotions or inflaming the passions. You also see some temperature language come in. We want juries to decide things, neutral evaluation of the evidence, some kind of cold evaluation of the evidence, as opposed to the passions of the jury or upon emotional reaction that's sort of hot. So you can have your arguments sort of flow through that. We want the neutral evaluation. We don't want too much emotions phrased in. And if you think about the typical cases for ripe for 403, and a lot of cases that decided on 403 go with crime scene photos and videos and day of the life videos and significant plaintiff's cases where there's real harm to the plaintiff caused by a defendant. And you can imagine there are certain photos in there that are really, at least an argument. They are susceptible to an argument by the opponent that this is designed to just get the jury mad and want to take it out on someone. This is designed to just inflame the passions of the jury, and that's not allowed. So that's the type of thing that you would use at the back end of your argument. So argue both sides of the scale. If you're the opponent, you start with the unfair prejudice or one of the other dangers. You go to the relatively low probative value. You argue that the scales are cranked sufficiently in the right direction under the rules so that unfair prejudice substantially outweighs the probative value. And then you say exercise your discretion, because this is really what's going on here. This is really what the proponent's trying to do. Conversely, as the proponent, I'm going to start with my side. I'm going to say it's not low probative value. There's some significant probative value here, and here's how it's going to be used at trial. Here's what I'm actually trying to do with this evidence. And then I would speak to their allegation of unfair prejudice and say, sure, that this evidence might be damaging to them. Sure, it might be prejudicial to them, but there's nothing unfair about it. There's no danger, as mentioned in the rule, as the way they put it. So therefore, the scales are not sufficiently cranked. The scales don't look like they need to under the rule, so that it cannot be said. This is not the case where this evidence, where some kind of claim of danger of unfair prejudice substantially outweighs probative value. It's not that case. So this is not the time, and this is not the occasion, Your Honor, to use your discretion to exclude this evidence under the rule.